Criminal Appeals is now in session. God save the United States, the state of Tennessee, and this honorable court. Please be seated.
Good morning. I want to welcome you to this historic June session of the Tennessee Court of Criminal Appeals here in Nashville. We are happy you chose to be with us today. Today is historic because it is the first time an appellate proceeding in the state of Tennessee will be live streamed on YouTube, and the public may call in and listen to the arguments live in real time. We wish to thank our staff of the Court of Criminal Appeals, the appellate court clerk Jim Hivner and his staff, and the staff of the Administrative Office of the courts for making all of this possible. We thank all attorneys for their cooperation and patience during this process. With everyone working together, we are attempting to return to a near normal proceeding for oral arguments. We are also providing the general public and the media with unprecedented access to oral arguments by attending in person, watching live streaming, or listening on a phone. Our presiding judge, Judge John Everett Williams of Huntington, Tennessee, has asked that we dedicate this historic session to the memory of Judge Tim Easter's father, Clyde E. Easter, who passed away 2 weeks ago as a result of COVID-19 at the age of 95, and to the hundreds of thousands of the victims of COVID-19 all over the world. Mr. Clyde E. Easter was an infantryman in the 3rd Division of the United States Army during World War II. He landed in Anzio, Italy. First wounded in the hand by machine gun fire, he was taken back, recuperated, and then returned to the front lines. He was later wounded by shrapnel in the face and received a Purple Heart with an oak leaf cluster for his 2 combat wounds. In honor and memory of his father, Judge Easter has brought with him today that Purple Heart with the oak leaf clover to set beside him at the bench. Judge Easter, you and your family are in the hearts of your colleagues, and we thank you for the service your father gave to this country. It was the efforts of Mr. Clyde Easter and all the millions of other soldiers who brought victory in World War II that allows for us to be here today in a free country and have court proceedings decided by a fair and impartial court. It is now my pleasure to introduce the panel assigned to hear the cases today. To my right is Judge Bobby Holloway from Columbia, Tennessee. To my left, as I noted, Judge Tim Easter from Franklin. I'm Judge Tommy Woodall from Dixon, Tennessee. As most of you well know, each side is allowed 20 minutes of time for their oral argument. If you represent the appellant, then you can reserve part of that 20 minutes for rebuttal time. And we will, due to the time limitations, we're going to pretty well have to stick to the 20 minutes on each side, though the protocol does allow for time periods between cases that a few minutes extra in oral argument can be granted by the court if necessary, in our opinion. Are you ready to proceed?
I am, Your Honor.
Call our case, please.
Abdur'Rahman versus the state of Tennessee.
May it please the court, Zachary Hink on behalf of the state. Your Honor, my condolences for your loss. I would reserve 3 minutes for rebuttal with permission. Thank you.
Fine.
Your Honors, this is really a simple case. It is a serious case, no doubt. The stakes are very high, not just for the petitioner, but really for the administration of justice in the state. But the question for the court to resolve, really the central question of this case, is straightforward, and the court's already answered it. Does the Post-Conviction Procedure Act permit a post-conviction court to commute a sentence on mere agreement of the parties? The answer to that question, based on the text of the statute and on this court's precedent, has to be no. As Your Honors know, Trial courts don't typically have jurisdiction to modify final judgments. 4035-319 and common law principles preclude it. But they can have specific grants of jurisdiction to modify final judgments by statute or by rule. In this case, the authority that was invoked was the Post-Conviction Procedure Act. But the authority to vacate final judgments in the Post-Conviction Procedure Act is conditional. It is not plenary. It requires a finding of constitutional error. And that's what this court held in Nichols just last year. That was not done in this case, but it wasn't the only flaw. There was no petition containing the claim that they purported to resolve. There was no hearing pursuant to that petition at which there was testimony. There was no preliminary review of the petition in which the court would consider the timeliness of the claim or whether it had been previously determined. And there was never even a finding that the basis of the claim, Foster versus Chapman, was a new and retroactive rule of law. In fact, the court explicitly reserved that question, as well as the basic timeliness of the motion to reopen. Your Honors, our position in this case is the court cannot sidestep those barriers. The parties cannot stipulate them away. The General Assembly's design is that at this stage of a proceeding, the bases to return to court to reopen post-conviction proceedings, and if appropriate, to grant relief, are narrow. The General Assembly has balanced competing interests to determine what types of claims can be litigated and when. And in this case, this claim simply can't be litigated because Foster versus Chapman is not a new retroactive rule of law, and because the court ultimately would have been required to find it was untimely, even if it had required a post-conviction petition. And so our position in this case, Your Honors, is that the court simply didn't have jurisdiction to vacate the final judgment, or in this case, to modify the final judgment from death to life. Your Honors, I'd like to speak a little bit about what I think is a really central issue in this case, which is Foster versus Chapman. And I think
we're not really here at this point to determine whether Foster versus Chapman even applies, are we? Because the state's premise to get this appeal is the court lacked jurisdiction to do what it did. Is that right?
Correct, Your Honor.
And if it lacked jurisdiction to do what it did, you have taken the position that that agreed order is void ab initio, correct?
That's right.
Okay. So the petitioner has not had his opportunity to present the issue to the trial court, who first determines. So if we take upon whether Foster versus Chapman is applicable, aren't we jumping in and doing what the trial court's supposed to do first in the posture that this is right now?
I think typically that would be true, Your Honor. I will note that he did present it in the motion to reopen, which is typically how it would be presented and where it would be resolved. I think what's notable in this case, of course, is the court has authority under Rule 13 to consider questions of law in the interest of judicial economy. And I think given the proceedings below, this would be an appropriate case to consider that pure question of law, which goes not just to whether the motion to reopen should be granted, but even if it were granted, if the claim would be timely.
There's
And so
no
it's
argument from the state that the motion to reopen was granted.
Your Honor, our position is that the motion to reopen was not granted because the court reserved the question of whether Foster versus Chapman was a new rule of law.
And that issue would have had to have been answered by the post-conviction court.
Correct.
Before the motion to reopen could be granted.
Absolutely, Your Honor. That would have to be decided by the post-conviction court.
Whether or not Foster creates a new issue of law.
Correct. And the court was aware of that. That's the hearing that the court set, was to decide whether not only whether Foster versus Chapman was a new and retroactive rule of law, but whether the motion was really relying on Snyder versus Louisiana and was therefore untimely, which is its own separate jurisdictional bar under 102A. So absolutely, the court was called to decide that question and recognized that it was. The case then languished for 3 years. And then it's ultimately resolved by an agreed order that doesn't contain any findings, including on whether Foster versus Chapman is a new and retroactive rule of law.
But if we accept your argument that the order is null and void. And in fact, your prayer for relief or conclusion in both your principal brief and your reply brief is what you're seeking is for this court to vacate the agreed order and any judgment that enforces that agreed order, period. You
Correct.
didn't ask us if you specifically as the appellant phrased the issues. The first issue is it's null and void and it should be vacated. The second and third issues, well, if it's not, if it did have jurisdiction, then you made arguments, but we don't even reach those if we agree with you on your first issue, do we?
I agree with that, Your Honor. I
Okay.
think that's fair
I
to
think
say.
your time arguing might be better spent focusing on your right to appeal this and why you think the trial court lacked subject matter jurisdiction to do what it did.
Your Honor,
You can argue, you're free to argue whatever you want, but
yeah, Your Honor, I think that's fair. And I think that when it comes to the right of appeal, in this case, the court really needs to look no further than the rule and State versus Dalton, or Dalton versus State rather, in which the state appealed a similar remission of a sentence. I think the state can appeal, not just because it has a right of appeal under Rule 3, but because there are interests that the state is defending that it can only be vindicated in this forum. And not just the finality of judgments and the orderly administration of justice, but also the governor's exclusive clemency authority. And so ultimately, I think the issues that they've raised on standing rely on a lot of authorities that really don't apply directly here, especially given that appealing and challenging jurisdiction from an agreement in a criminal case is not foreign to this court. Defendants can do that. And although it is uncommon, the state has done that. And we often take positions on appeal that are different from what the district attorney general attempted to take in the trial, or did take rather in the trial court, including questions and almost exclusively questions of jurisdiction. Certified question cases, delayed appeals where it wasn't properly followed. We're not bound by the fact that the district attorney general agreed there was going to be jurisdiction, because jurisdiction is so fundamental to questions of justice. It's so fundamental to the orderly administration of justice.
What does the state argue that the post-conviction court should have done to establish subject matter jurisdiction?
Well, Your Honor, the court should have considered the Foster versus Chapman issue. The court should have then ordered that the case proceed under the act, which would require a petition containing the claim and a preliminary review. And frankly, at that point, Your Honor, the court's jurisdiction would have to end because it would have to go through 102B, which again considers Foster versus Chapman's retroactivity, given that it's not retroactive. And I understand Your Honor's point on that. But given that it's not retroactive, without getting into the question, then that's a separate jurisdictional bar in and of itself.
are you saying that the court loses jurisdiction if it makes what the attorney general considers to be the wrong decision?
I'm saying, I'm
If the
sorry.
trial court says, yes, I'm gonna reopen this, and now you get to proceed and offer your proof to show you're entitled to post-conviction relief, are you saying at that point, the trial court has lost subject matter jurisdiction?
Your Honor, I'm saying under the statute, it doesn't have jurisdiction to consider an untimely claim. So, and that's nothing new. I'm not asking the court to break new ground there. That's what
Where
the court,
was it late in
because it's clearly past a year since the finality of the judgment. And so the only way it can be timely is to go through 102B. That's why it mirrors 117A. They're both bars. One is a bar to reopening, and because it's discretionary, it does take into account, is this a basis to reopen? And
it
to,
was filed within 1 year that Foster was filed, wasn't it?
the motion was timely,
Yeah.
but the claim is not timely if Foster versus Chapman is not a new and retroactive rule of law. That's what the court said in Nichols. That's what the court said in Sutton. And they're just applying
Yeah.
Coleman. And it's, I'm sorry.
Nichols is not a published opinion.
It's
yet,
not, Your Honor.
So it's just persuasive.
That's
authority.
correct, Your Honor. Absolutely.
Okay.
But Nichols is relying on not just the language of the act, but the Supreme Court's decision in Coleman, which said that even just because you reopen doesn't mean you start anew. You still have to go through the timeliness provisions, including 102B, which is why it mirrors 117A. And of course, it's not directly relevant here because they never even got there. But if they had, that would have been a separate jurisdictional bar and a bar that would prevent them from then going to a hearing. And the court would be required to consider it, that and previous determination.
Now, kind of following up on Judge Holloway's question, are you saying that in this proceeding, if, and I believe the judge set the hearing for August 29th, is that roughly it's the same day as the agreed order was entered? Is that
Yes,
correct?
that's roughly. I can't
Okay.
remember exactly the date.
He sets the hearing and the judge looks at it and hears what the proposed settlement is. And the judge says, okay, I approve your settlement. Foster meets the criteria. It created a new rule of law. It's timely filed. And under Foster, your rights, your constitutional right was violated. Therefore, you're entitled to post-conviction relief. And that would go to all three convictions because they were all tried together, probably.
They were.
And then if immediately the state said, Your Honor, in anticipation of your ruling, we've reached a plea agreement with the petitioner, and he is going to waive his right to post-conviction relief on the attempted murder and the robbery, but he is going to plead guilty now instead of making us go to trial on these three charges. He will plead guilty again to first-degree murder, and we agree to a sentence of life imprisonment. And all that went down. Are you saying at that point there's a lack of subject matter jurisdiction for the court to do that?
I'm saying at that point it's untimely and there's a lack of jurisdiction under 102B. Because it says there shall be no jurisdiction unless it is a new retroactive rule of law.
It doesn't say there's no jurisdiction. I mean, and you are aware, I think, as I understand, initial post-conviction petitions, there is a 1-year statute of limitations. And as I take it, the General Assembly, in order to prevent the petitioner from getting around the statute of limitations if the district attorney fails to allege statute of limitations as an affirmative defense, the legislature specifically said in the statute that the statute of limitations in this case is jurisdictional. No court or parties can agree to waive the statute of limitations and give jurisdiction. They didn't put anything like that in the petition or motion to rehear statute, did they?
Your Honor, and I'm not referring to 117, I'm referring to 102B.
I know what you're referring to, but the legislature took steps in the Post-Conviction Act to specifically say that the statute of limitations is jurisdictional on the initial petition. They did not take the step of saying that this criteria that we're setting up to allow a motion to reopen is that the statute of limit, that anything that we say here is also jurisdictional, did they?
Your Honor.
Did they put in there that this criteria is jurisdictional and it cannot be waived by the trial court or the parties?
When it comes to the statute of limitations, yes. The 117 is an exception to the one petition rule. 102B is an exception to the statute of limitations. 102B is jurisdictional. Even if you get reopening, it still has to go through that review. That's what the Supreme Court said in Coleman. That's what the court held in Nichols. That's what the court held in Sutton.
Okay.
That's my point, Your Honor. I think it's fair to say 117 doesn't have that jurisdictional language. But what I'm saying is, to your question, is if they had gone through met all these steps, cured the Nichols problem, and all those other issues, there's still a jurisdictional problem because of the timeliness of the claim. The problem is that they can't get around the fact that Foster v. Chapman is not a new and retroactive rule of law. There's just no way of avoiding that because even if you get reopening, then it becomes a timeliness problem as to the claim. And now we didn't even get there in this case, given the procedure, but that's the point that I'm making in response to your question about, well, if they had gone through all the steps, would they still? Now, if it were a new and retroactive rule of law, that did toll it, and they went through those steps, then absolutely, I agree, they have jurisdiction to do it under the act, to do it exactly as you said.
In your reply brief, and maybe in your principal brief, aren't you suggesting, though, that the petitioner still has a remedy? That is to go back and do just what I think Judge Woodall was pointing out, that you have the hearing, but now you're saying it would be untimely.
I think the remedy, it's not a remedy so much as he still has the opportunity to have his motion to reopen ruled upon on the merits. He's not lost that opportunity at all. My point is just, in the absence of a new and retroactive rule of law, there's no timely claim. I'm sorry.
Sorry, go ahead. Finish what you were saying.
Oh, no, Your Honor, please.
Is the state seeking a remand of this case, or are you seeking a reversal of the trial court's order?
Well, I think the first and foremost, and as Judge Woodall noted, we're seeking vacation of the agreed order in the amended judgment. Now, the court could, I think, in its discretion under Rule 13, decide the ultimate legal question, but it's certainly not bound to. I think that's fully a question within the court's jurisdiction. The immediate relief that we are seeking is to vacate this order, vacate this amended judgment, and let the matter proceed on the legal question. Let the matter proceed on the legal question of whether Foster versus Chapman is a new and retroactive rule of law. And the petitioner still has that. That will be decided, regardless of how the court resolves it. That will be decided either by the court in deciding to take it up under Rule 13 or by the post-conviction court on remand.
Would, if we hold that your appeal was proper, your right to appeal, and just set everything aside that was done, is that going to be precedent for defendants in the future who may enter into an agreement in the trial court and then get another lawyer later who wants to appeal it and says it wasn't fair and get it set aside? Is that going to, I mean, just to get the appeal, they may not get the relief like you want, but are we going to be flooded with this being precedent? And I say that, especially in the recent legislation that set up the public defender appellate division. 2 different lawyers. You'll have a public defender in Bledsoe County that settles a case for a defendant. The defendant thinks about it a little bit. The appellate division attorneys raise it, file a notice of appeal, and all that stuff about settling the case is out the window. Is this going to be authority that defendants can start doing this as long as they get another lawyer to represent them?
Your Honor, I don't think so, because what we're presenting to you is purely a jurisdictional question, and they can already do that. A defendant can already agree to a plea agreement and raise a jurisdictional question on appeal, And defendants can collaterally attack those agreements if it's a void judgment, like in this case under habeas, under Rule 36.1. That's already true. I'm not arguing that if the district attorney had this authority and if the court had this jurisdiction, we could appeal to this court and ask you to come to a different conclusion. What we're presenting to you and what we believe this case involves is a fatal jurisdictional flaw that creates a very significant question about the validity of this order, which ultimately impacts a pending Supreme Court order setting an execution date. And although it's been stayed, it's not been vacated. And so we think that's a matter of law that goes straight to the jurisdiction of the court, that involves that pending order, that is unusual, that is not going to cause a cascade. Now, of course, I can't control what other attorneys will cite and argue, but I don't think it will cause a cascade of new cases where they're trying to renegotiate on appeal, if you will. Because yes, if the court were to find that there was jurisdiction and authority, then we would lose, because the petitioner would absolutely be right that we had waived rights. Absolutely.
Okay. You've used up 20 minutes right now, but we've asked you a lot of questions, so I'm going to let you still have 3 minutes you asked for in rebuttal. We'll turn it over to the appellate.
Okay, thank you, Your Honor. I appreciate that. Thank you.
May it please the court.
Sorry, I keep looking straight ahead.
I apologize, Your Honor, that it's strange for me to sit down. I'm sure it's unusual.
No problem.
I want to start also by offering my condolences, Judge Easter, and appreciate the fact that these proceedings are dedicated to your father's memory, which seems
Thank
very appropriate. My name is David Esquivel. I'm with the law firm of Bass, Berry & Sims. My co-counsel is Mike Tackett, Brad McLean, Catherine Dix, and Kelly Henry. We represent Mr. Abdur'Rahman. Your Honors, this is a case about broken promises. The prosecutor who tried Mr. Abdur'Rahman was asked to speak recently before the statewide conference of district attorneys on how to pick a jury. And he said these: all blacks hate Mexicans. He was referring to a recent case he prosecuted against Hispanic defendants in which he impaneled an all African-American jury. His message to the prosecutors at the statewide conference was clear: race is important. Use race in picking a jury. The Constitution includes a promise that citizens will not be denied service on a jury because of the color of their skin. It is a basic promise, and Mr. Zimmerman broke it. And this proceeding was filed to hold the state accountable for breaking that promise, which leads to the second broken promise. To avoid the risk of losing and jeopardizing the conviction in this case, the state made an agreement with my client. My client promised to end more than 30 years of litigation and spend the rest of his life in prison. The state agreed not to execute him. If my client accepted the deal, the case would be over. My client accepted the deal. Yet here we are. We believe the Attorney General is asking this court to do something that no court anywhere in this country has done, and that is to allow the state to agree to a sentence entered by a judge, then appeal and ask the appellate court to impose a harsher sentence. This court should not allow such an outcome. We are asking this court to dismiss the appeal. Parties cannot appeal from relief they sought and received in the trial court. If the court considers the merits of the appeal, the court should affirm the trial court's decision because the court did have subject matter jurisdiction to review the agreement and enter it as an order. Let me start with the question of appellate jurisdiction. This court lacks jurisdiction to hear the appeal because consent orders are not appealable orders. The Court of Appeals has gone so far as to call those appeals frivolous. The state, through its trial counsel, agreed to resolve this case in the trial court, and the state persuaded the judge to accept the agreement. Now, different counsel for the state has filed an appeal and wants to erase the state's agreement below. But lawyers do not have standing. Only parties have standing. A party cannot ask one lawyer to enter an agreement in the trial court and then ask a different lawyer to upend that agreement on appeal. The law doesn't allow it. No party can do that, not even the state. I think on this question, Your Honors, there's an important case that we've cited in our brief, and it's the Watkins case, State versus Watkins. And Watkins talks about this issue in the context of waiver. And whatever this court does, I think it's important for the court to consider Watkins. Watkins is a Tennessee Supreme Court case that involved a range classification that was wrong. The statute said that the defendant shall be sentenced in range 2 with mandatory language. But the district attorney in that case, in a plea bargain, actively encouraged the trial court to sentence the defendant to a range 1 sentence. On appeal, the Attorney General argued for the first time that the defendant should have received a range 2 sentence because the statute said shall. It was not permissive, it was mandatory. This court agreed with the Attorney General, but the Supreme Court took the case and reversed and held that even though the sentence violated the requirements of the statute, the agreement by the prosecutor was what controlled. In Watkins, the Tennessee Supreme Court rejected the same argument that the Attorney General's office is making here.
Let me ask you a question about that. Do you see any distinction based upon the posture of this case we're talking about, in your client's case, post-conviction, which is driven by statute. And in the Watkins case, I believe that was a direct appeal from a plea agreement. Is that right?
That's correct, Your Honor.
In your mind, is there any distinction of those two, since one is appealing a plea agreement and the other is appealing a post-conviction agreement that's driven by the statute that allows reopening and the whole jurisdictional issue that the state's raised? You see any distinction?
I would agree the distinction is that there are different levels of the proceeding, and that Watkins involves in the initial stage from a plea agreement.
Right.
And this case involves post-conviction. But I think that distinction doesn't matter because they both involve mandatory statutory language or statutory language. In other words, in Watkins, the court is interpreting the sentencing statute, and in this court, the court is interpreting the Post-Conviction Act. They are both creatures, they are both statutes, they both enact provisions of law. And the distinction in this case, the post-conviction, I think, falls away because they both really are questions of statutory interpretation. And weighing a mandatory statute versus an agreement that a prosecutor makes with a defendant, or in this case, a petitioner in the trial court.
Ms. Gressel, let me
Yes.
ask you about jurisdiction. That's what's troubling me about this case. When you read 4030-102B and 4030-117-1A or A1, they basically contain the same provision the way I read it, since it says only if to establish jurisdiction. Now, let's say we agreed with everything in your argument, but we did not think the trial court made the appropriate findings, or the post-conviction court made the appropriate findings to establish jurisdiction under these two statutes. Would you agree that if that was the issue, the state could appeal a jurisdictional challenge or jurisdictional issue?
I would agree that the subject matter jurisdiction of the trial court is always an issue. Every court at every stage has the obligation to assure that both this court and the trial court have subject matter jurisdiction. So by virtue of, if this court accepts, and there's a tension here, of course, between the law that says consent orders cannot be appealed, therefore there's no jurisdiction, and the obligation of a court to assure subject matter jurisdiction. But I would say, Your Honor, that in terms of the ability to be in this court, it is certainly the case that the court must assure itself that the trial court had subject matter jurisdiction.
I'm sort of going back to what Judge Woodall asked. I think we have to answer the jurisdiction question before we even get to whether Foster created a new rule of law. Until we answer that question, I think we're not going to be able to go much further.
Well, Your Honor, I don't believe that whether Foster is a new rule of law is an issue at all, for the reasons that Judge Woodall was suggesting, which is those are merits issues. That is a merits issue. That is the issue that was to be decided at the hearing that Judge Watkins set, that was set in October. And by compromise of the hearing that was pending, the merits issues fall away. In other words, if the Attorney General is to be taken at his word that this is a challenge to subject matter jurisdiction, then whether Foster is retroactive or not retroactive, that's a merits question. That can't be a jurisdictional question. I mean, this court's precedents are clear. The Tennessee Supreme Court precedent is clear. Jurisdiction is the capacity of a court to act. It is not whether the court got a decision right or wrong in a particular instance. So if the Attorney General is arguing here that this court, that the criminal court of Davidson County had no capacity to enter a post-conviction order, then argument has to go to that. And the retroactivity is a merits question, and merits can never be a subject matter jurisdiction question.
So in the future,
I'm sorry.
Go ahead.
Are you arguing this court doesn't have jurisdiction, or the Davidson County Criminal Court had jurisdiction, because that's the issue I think that we've got to resolve, is whether or not Judge Watkins had jurisdiction initially to do this.
Yes, I think we're arguing both. Though I honestly don't want to be detained too long by this court's subject matter jurisdiction, because I think the question of whether Judge Watkins had subject matter jurisdiction is resolved easily in our favor with statutory interpretation and alluding to some of the things that Judge Woodall was asking counsel for the state about. And if I could go through that argument, because I think it really is the crux of this case. The criminal court, the Attorney General is making the argument here that the criminal court for Davidson County lacked the power to make any decision at all, that it lacked subject matter jurisdiction. I think to see why this is wrong, it helps to look at the proceedings below chronologically. Mr. Abdur'Rahman filed a motion to reopen post-conviction. The Attorney General concedes on page 14 of his reply brief that the court had jurisdiction to consider the motion to reopen. So the parties agree that Judge Watkins had jurisdiction to rule on the motion to reopen. Again, jurisdiction is the power to act. It doesn't require a case to be decided a certain way. So whether Judge Watkins got the question right or wrong on the motion to reopen, the state concedes he has jurisdiction. So there's no problem at the section 117 motion to reopen stage. Both parties agree there's jurisdiction. So now in the trial court, we have a reopened post-conviction petition that is set for hearing. And at that point, the district attorney in this case did what a district attorney does and every lawyer does in this state every day. He considered a compromise to a disputed issue. He reviewed the record. He considered the risk of the court finding a structural error that would vacate the conviction. He consulted with the victims. He reached an agreement and the parties proposed it to the judge. The judge took it under advisement. He studied it and he entered an order that enacted their agreement. The Attorney General is here saying none of that is possible, that post-conviction cases are unlike any case in any other part of the law. The Attorney General's position is that post-conviction can never be settled. Every single case in post-conviction, according to the Attorney General, the trial court must make an independent finding that the petitioner would win in a contested hearing, regardless of whether it is a close question or not. Now, this is wrong for several reasons. First, the idea that parties cannot compromise, cannot settle, is unheard of in the law. The law favors settlement. The law encourages settlement. Civil and criminal disputes are settled every day. Second, nothing in the Post-Conviction Procedure Act suggests that the legislature intended to make the statute unlike any other it enacts, one that would prohibit settlement. If the General Assembly wanted to create that kind of cause of action, one that required the judge to ignore the parties, to ignore the lawyers, to make independent inquiry on the petitioner's claim and find that it must prevail, then we would expect the General Assembly to say that directly. In the Post-Conviction Procedure Act, the General Assembly did not say that, just the opposite. And the court has already focused on this, which I think is a critical part of this case. Section 102B of the Post-Conviction Procedure Act contains the only language in the act with a jurisdictional requirement, and that is for late filed petitions. The General Assembly clearly said in 102B, if you file your petition after the expiration of the statute of limitations, then the trial court, in order to have jurisdiction, must find one of these three things. That jurisdictional language is not present in Section 117. That jurisdictional language is not present in Section 111. That jurisdictional language only exists in 102. And so given that the legislature specifically chose not to include jurisdictional language in Section 111 and not to include it in 117, basic canons of statutory construction tell us what to do when the legislature uses one word in one part of a statute and omits that word from the other part. And that is that the language of Section 111, language of Section 117 is not meant to be jurisdictional.
I need to ask you a question that pertains to this a little bit, what you're arguing, but I wanted to ask a question before your time runs out. I'm a stickler for rules and following statutes, and the only relief that I understand you can get in post-conviction is to set aside the conviction or the sentence. The statute's very specific in that. Now, I think one thing that I'm wrestling with, it appears that the trial court skipped a step in approving the settlement. And this really doesn't have anything to do with jurisdiction, but it skipped it. If the court approved, based upon a settlement with the DA, that the defendant was entitled to post-conviction relief, then I think the court must say somewhere, make a finding, if it's by stipulation but of evidence between the DA and the petitioner, has to make a finding that he is entitled to post-conviction relief, and that as a result thereof, all three convictions have to be set aside. Of course, that would set aside the sentences. And then if the district attorney and the petitioner present to the court in anticipation or as a result of your decision, we have reached an agreement to settle this matter so that we do not have to retry all of three of these. And then the defendant is going to plead guilty again to all three offenses. And he, in the plea agreement, he agrees that he will receive consecutive life sentences for each one of them. Now, some people might say that's form over substance, but I see it as that's the proper way, the steps that have to be taken to have a settlement of a post-conviction matter, whether it's the first post-conviction or a motion to if it's reopened by a successful motion to reopen. And those aren't jurisdictional steps. That's just what I think should have been done. So how, I mean, in just vacating, you don't want us to vacate the judgment like the order. Kind of explain to me how you met that criteria with the district attorney to follow the specific steps that the Post-Conviction Act requires.
Right.
And this doesn't have anything to do with jurisdiction. It doesn't change my concerns
No,
about
I understand
jurisdiction.
Your Honor's concerns that the record below shows a blurring between the remedies available by the Post-Conviction Procedure Act, which would be to set aside or vacate the conviction and sentence, and then essentially to reopen the underlying criminal proceeding from way back in 1986 and enter a new plea and have a new sentencing recommendation and new sentencing proceeding. And formally, that is how it should have been done. And
well, what raised my concern about this was the state's arguments that what was done violated the power only reserved to the governor to commute a sentence. And so.
But I would say, Your Honor, that what happened below, if anything, is more of the form over substance than truly the clemency power. Probably the court below clearly did not believe it was exercising clemency or was doing something outside of the bounds of the statute. The court intended, I think, to grant the relief available under the Post-Conviction Procedure Act.
But the court below just focused on the first-degree murder conviction, correct? I mean, if I understand what Judge Waddell's asking, what about the other convictions? If one is set aside, aren't they all three set aside?
Yes. Well, that is, the relief would have applied to all three of the convictions. And I would say that if the court has concerns about the mechanism by which this was done, if the court agrees with us that because it has been the practice in this state for a long time that the Attorney General has had notice of that post-conviction cases can be settled and are settled. If the court's concern is that this settlement did not occur in the way in which, the formal way in which the Post-Conviction Procedure Act contemplates, that is vacating the convictions and then entering into a new plea agreement, then that could be accomplished on remand. I don't think it's absolutely necessary because I think the record is clear enough that that's what Judge Watkins intended to do. But if that's the court's concern to follow, the strictures of the act in that way, then I think a remand to do that with those specific instructions would be appropriate.
You have, your 20 minutes are up, but I'm gonna give you 3 more minutes like I'm giving the state in addition.
Thank you, Your Honor. I appreciate that very much. I think I do want to say something about the court's decision in Nichols because it featured so prominently in the state's briefing, and Judge Easter, I'm aware that you were the author of that decision. We don't think that Nichols compels a contrary result in this case. Nichols holds that a trial court is not required to accept the settlement agreement of parties where the trial court makes a determination that the petition could not have any merit. That's what Nichols holds. If this case were Nichols, I would be sitting where Mr. Hinkle is sitting, and he would be sitting where I'm sitting. But I am not here arguing that the trial court abused its discretion in anything it did, that the trial court was required for some reason to enact an agreement that we made. I'm here as the appellee, upholding the trial court's discretion. This court held in Nichols that the trial court did not abuse in its discretion in rejecting the settlement agreement. And we are here saying the trial court did not abuse its discretion in accepting this settlement agreement. So I think Nichols is a different case. I think the holding of Nichols is consistent with the outcome in this case. I also want to refer to our collective Exhibit A because in determining how to interpret the statute, and this is really a question of statutory interpretation, is there anything in the Post-Conviction Procedure Act that makes it impossible to settle those cases? That is the crux of this case. It is certainly not binding precedent on this court, but it's instructive that the Attorney General's office receives notice of all of these settlements and has never sought to assert that those settlements were done without subject matter jurisdiction. This is the first time the Attorney General has made that argument. And our collective Exhibit A demonstrates that in at least 10 capital post-conviction cases, the parties have reached an agreement, a compromise in post-conviction. And the court has entered that agreement pursuant to the parties. The Attorney General has received notice, and the case is resolved. So in terms of statutory interpretation, I think it's proper to look at what the practice in this state has been, what the practice of the Attorney General's office has been, and that practice has consistently recognized that post-conviction cases can be settled.
You've used up your time.
Okay.
Can I ask
Thank you
one more
very much,
question?
Your Honor.
Oh, yeah.
I'm troubled by the fact that, based on your position, it seems that it completely does away with the requirement under 403117A1, or if you want to look at 102B, that the claim is based on a final ruling of an appellate court establishing a constitutional right that was not recognized. Now, if the trial judge doesn't have to find that, why can't in the future, if someone decides they want to do away with all the death penalties in the circuit, just simply file a motion to reopen? That's all it needs to say. Let the trial court assign an agreed judgment commuting the sentence to life. And under your argument, the court had jurisdiction and the state can't appeal that. Would you agree with that prognosis.
I understand the fear of the rogue prosecutor or the rogue judge or the combination of those entities that would result in something that this court or the Attorney General's office or others would find to be troubling.
Or the people of the state of Tennessee.
Or the people of the state of Tennessee. I understand that, but what I would say is that in this case, look at what the judge actually did. There were 3 bases for motion to reopen. A dissent in Glossip, the Obergefell decision on marriage equality, and the Foster case. And the trial court in this case said to 2 of those, no, as a threshold issue on a motion to reopen, those are not retroactive laws that are applicable here. The trial court has a gatekeeping function. We trust trial judges to make these decisions. This is a statute that vests incredible discretion in the trial court. The decision on the motion to reopen has no right to appellate review. A denial of a motion to reopen comes to this court on an application for permission. And then if this court gives permission, then it reviews it for an abuse of discretion. That whole system puts enormous, empowers the trial judge to exercise a lot of discretion, as we do with trial judges. So the first thing I'd say, Your Honor, is we have a system where we trust that trial judges are going to exercise good judgment. And I would say consistently that we do. I would say we do the same thing with prosecutors. If there is a rogue prosecutor that is acting in the way that Your Honor suggests, that is distasteful to the people of state of Tennessee, if a prosecutor is out, the remedy is not, I would suggest, to create a jurisdictional requirement in the Post-Conviction Procedure Act where none exists. There are remedies for that. Any lawyer, including a prosecutor who is running amok, is subject to the Board of Professional Responsibility. And the prosecutor and the judge, in particular, are ultimately subject to the ballot box. And that is a well-established foundational principle of our government and society. If we have a district attorney who is acting inconsistent with the interests of his constituents in the state of Tennessee, then the remedy is to vote him out of office. And that is how that remedy works. And I think the scary part underlying your question is that we know prosecutors enjoy an immense amount of discretion. This court has recognized that. It is a truism of our system. And so part of the answer to your question, Judge Holloway, is that this is a part of our system, is we have to trust prosecutors because we empower them with significant discretion.
Okay, thank you.
Thank you.
I'm
Just
going to be abundantly fair.
okay.
You'll have about 7 minutes if you need it.
Okay, I don't think I will, Your Honor. I'll just be brief. I'm going to push this away because I'm apparently making it angry. Your Honor, just briefly, the jurisdictional point about 403111. The jurisdictional language is in 4035-319. Courts don't have jurisdiction to modify final judgments. 403111 gives them that authority. It is by nature jurisdictional, and it is conditional on a finding of constitutional error. And I think that's what's notable about these settlements that they found is looking through the orders that they provided. Of the 10, 7 have explicit findings that the judgment is void. They're following the protocol that Your Honor has discussed. Of the remaining 3, one of them just vacated the sentence and went to retrial. One of them was an intractable constitutional conflict in which the Supreme Court had remanded for hearing, and the court found that the petitioner was incompetent to proceed. And so they found one with a similar commutation in apparently 3 decades of canvassing, one that I know we weren't aware of until months later, because we aren't always served despite the statute's requirement. And so I actually think that's notable that what they've been able to find is following the strictures of the act. What we're saying is that this case did not. And when they say our opinion, that this is our opinion, it's not just our opinion. This is what the court held in Nichols as well. And the court absolutely has the discretion to go the other way. But it's not as if we're fantastical in our interpretation of the statute and what the statute requires. And Your Honor, I'll leave you with this thought. The parties below wanted to commute the sentence. There is a person in the state with that authority, and they can direct their advocacy to the governor who has that authority at any time to achieve this desired result. And unless the court has any questions, I'll leave you with that.
No,
Thank
thank you
you.
very much. I'm sure all of you read the protocol that you're supposed to clear the courtroom as expeditiously as possible so that the staff can do some cleaning for the next parties that come in. So thank you for being here today and participating.